majority of claims against employers arise at the time of termination of employment. Here are 5 tips to help you navigate the termination process. 1. Make sure you know the terms and conditions that apply to the employee. Review applicable contracts, awards, and enterprise agreements, as well as any relevant policies. Sometimes employees have special conditions you don't know about. Double check this before you start. Consider all applicable processes. Contracts, enterprise agreements, and company policies often set out a way a disciplinary, misconduct, or redundancy process must be conducted. Failing to comply may impact the lawfulness of the termination. Again, it's best to check these processes before you start and make sure you comply with them throughout the process. Next, understand the reason for the termination. Where the employer can access the unfair dismissal provisions, it's particularly important that you have a sound and defensible reason for the termination. But even where the employer can't access those provisions, it's important to have a clear sense of the reason for the termination so that you're in a position to defend any claim that the termination is for a discriminatory or prohibited reason. Next, ensure procedural fairness. Whatever the reason for termination, it's important that employers are given an opportunity to respond. This might take the form of a right of reply in a disciplinary process or consultation in circumstances of redundancy. Ultimately, it's better to hear what the employee has to say and consider it prior to the termination than only hearing about it after proceedings have been issued. Finally, make sure termination payments are correct. Once the termination has been effected, make sure you properly calculate an employee's entitlement, including where applicable the payout of leave, RDOs, and severance pay. If something doesn't look right, check it with payroll. A planned and measured approach throughout the termination process is the best way to minimise a legal claim.